Tell me first how you think things went.
Well, look, I think what was very clear was that the overall case was very hotly decided. I mean, the bottom line was there was no clear one direction. We heard two cases today in the courtroom. One was clearly was slanted one way. This case, you could tell there was fear among the judges on how do you write this decision if you were to say Aereo is illegal. How do you write the decision without impacting cloud computing? There was a lot of concern about how you keep this from impacting other industries. And, Chief Justice Roberts actually went after the plaintiff's attorney saying, well, isn't Aereo just like using a public parking garage? You go to that public parking garage and you're renting space for X amount of time. How is that different than if you go home and you build a garage? Isn't that the Aereo analogy that you are essentially renting versus buying? And I think that's the key challenge the court is grappling with is this simply the same thing as renting versus buying, or is there something special about broadcast television?
Those are a lot of the questions we expected as well from the justices. Were there any curveballs, Rich?
I think in terms of curveballs, probably not. I think there was some concern when you think about what the overall impact could be on, why the system is the way it is. There was a comment from Justice Ginsburg, basically, is the only reason you're creating millions of individual copies to circumvent copyright law. And I wouldn't call that a curveball, but I think the pushing on why is the system built this way, is it only built this way to circumvent copyright law, was certainly another key theme.